We are Group 1 and we will be reporting on Chapter 2, Jurisdiction and Choice of Law.
So how does one deal with a problem in conflicts of law? The first thing we need to determine is whether or not the court has jurisdiction. So as we all know, there are several concepts of jurisdiction. The first is jurisdiction over the subject matter, which is conferred by the Constitution and BP 129. Jurisdiction over the subject matter is conferred by law and is the power to hear and determine cases of the general class to which the proceedings in question belong. This jurisdiction cannot be conferred by consent of the parties or by their voluntary submission. Jurisdiction over the subject matter is invoked by the filing of the proper complaint or petition with the court. The allegations of the complaint or petition, read in light of the proper jurisdictional law, confer jurisdiction on the court. However, in the realm of conflicts of law, there is another element that the court must consider when it comes to jurisdiction over the subject matter, and that is the enforceability of its decision in foreign states subject to the rights of the said states. In conflict of laws, jurisdiction is the power of the court of the forum to render a decision that will create legal rights and interests which other states will recognize and enforce. We'll now move on to jurisdiction over the person. So jurisdiction over the person is the competence or power of a court to render a judgment that will bind the parties involved. Jurisdiction over the plaintiff is acquired the moment he institutes an action by filing the proper pleading. On the other hand, jurisdiction over the defendant is acquired when he enters his appearance or via court summons. Another concept of jurisdiction is jurisdiction over the res. So this is jurisdiction over the particular subject matter in controversy, regardless of the persons who may be interested therein. The basis of the exercise of this jurisdiction is the presence of the property within the territorial jurisdiction of the forum, even though the court may not have personal jurisdiction over the persons whose interests in the property are affected. The purpose of the suit is not to impose a personal liability on anyone, but to affect the interests of all persons in a thing. So an example of this are actions in rem, which are actions against the res or thing itself. So the jurisdiction in these actions is called jurisdiction in rem, which is the kind of jurisdiction where the purpose is for the judgment to bind the whole world insofar as the res or thing is concerned. Examples are land registration cases and admiralty cases. We also have actions in personam, which are actions against a person on the basis of his personal liability or one affecting the parties alone, not the whole world. So the jurisdiction in these kinds of cases is jurisdiction in personam, the kind of jurisdiction which binds only the parties and their successors in interest. Examples are recovery of damages and specific performance. Next, we have actions quasi in rem. In actions quasi in rem, the purpose is neither to impose a personal liability or obligation upon anyone, nor affect the interests of all persons in a thing, but to affect the interests of particular persons in a thing. So this is an action affecting the personal status of the plaintiff. In such case, the court may render valid judgment when it has jurisdiction over the particular persons whose interests are affected. Examples of this are foreclosure of a mortgage, partition of land, or an action to quiet title to property. So our next topic is how the service of summons is effected. For personal service, summons shall be served by handing a copy thereof to the defendant in person and informing the defendant that he or she is being served, or if he or she refuses to receive and sign for it, by leaving the summons within the view and in the presence of the defendant. So if personal service fails, summons can also be served via substituted service. So this is done by leaving copies of the summons at the defendant's residence to a person at least 18 years of age and of sufficient dissection residing therein. Substituted service can also be made by leaving copies of the summons with the officers of the Homeowners Association or the chief security officer of the community where the defendant may be found. And if the court allows, it can also be emailed to the defendant's email address. Service can also be made by publication. Summons by publication is authorized only in 3 cases: if the action is in rem, if the action is quasi in rem, or if the action involves the personal status of the plaintiff.
Extraterritorial Service. Section 17, Rule 14 of the 1997 Rules on Civil Procedure provides for instances where an extraterritorial service of summons may be made, namely a. when the defendant does not reside or is not found in the Philippines and the action affects the personal status of the plaintiff; b. when the defendant does not reside or is not found in the Philippines and the action relates to, or the subject of which is, property within the Philippines in which the defendant has or claims a lien or interest, actual or contingent; c. when the defendant is a non-resident but the subject of the action is property located in the Philippines in which the relief demanded consists wholly or in part in excluding the defendant from any interest therein; and d. when the property of a non-resident defendant has been attached within the Philippines. While a writ of attachment may be issued by the court upon application, said writ cannot be implemented until the court has acquired jurisdiction over the non-resident defendant. Without such jurisdiction, the court has no power and authority to act in any manner against the defendant, and any court order to that effect will not bind said defendant. How may extraterritorial service be affected? Section 17, Rule 14 of the 1997 Rules on Civil Procedure provides that such service may, by leave of court, be effected out of the Philippines: a. by personal service; b. as provided for in international conventions to which the Philippines is a party; c. by publication in a newspaper of general circulation in such places and for such time as the court may order, in which case a copy of the summons and order of the court shall be sent by registered mail to the last known address of the defendant; or d. in any other manner the court may deem sufficient. Section 17b is a new addition to the old provision. So the court has jurisdiction, but there are instances when the court may refuse to exercise jurisdiction on the basis of forum nonconvenience. What is forum nonconvenience? Forum nonconvenience allows courts to decline to exercise jurisdiction that otherwise exists in deference to litigation in a more appropriate forum in another state. So even if the court has jurisdiction over a conflicts case, the court may, by invoking the principle of forum nonconvenience, refuse to exercise or assume that jurisdiction in view of any of the following practical reasons. So a. the evidence and the witnesses may not be readily available in the forum. b. the court dockets of the forum may already be clogged, so that to permit additional cases would hamper the speedy administration of justice. c. the belief that the matter can be better tried and decided in another court jurisdiction, either because the main aspects of the case transpired there, or the material witnesses have their residence there. So d. to curb the evils of forum shopping. That is, the non-resident plaintiff might have filed the case in the forum merely to secure procedural advantage or to annoy or harass the defendant. E. the forum has no particular interest in the case, the parties not being citizens of the forum or are residents elsewhere. or the subject matter of the case evolves somewhere else. F. Other courts are open and the case may be better tried in said courts. G. The inadequacy of the local judicial machinery for effectuating the right sought to be enforced by the plaintiff. Or H. The difficulty of ascertaining the foreign law applicable. The doctrine should generally apply only if the defendant is a corporation. For if the defendant is an individual, the proper forum may not be able to acquire jurisdiction over him. For example, he may not be residing there, thus leaving the plaintiff without any remedy. So after the court acquires jurisdiction, which law should the court apply? Domestic or foreign law? Domestic law. Lex 40. So there are at least 3 instances when the forum has to apply the internal or domestic law, Lex 40, in deciding a case in conflicts of law. They are A. When the law of the forum expressly so provides in its conflicts rules. B. When the proper foreign law has not been properly pleaded and proved. C. When the case involves any of the exceptions the application of the proper foreign law, exceptions to comity. So here are some examples of cases which require the application of Philippine internal or domestic law. A. Whenever land involved in the suit is located in the Philippines, Philippine law or the lexitus is applied, as provided for in Article 16, first paragraph of the new Civil Code. B. Regarding the property relations of the spouses, Article 80 of the Family Code provides that in the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by Philippine laws, regardless of the place of the celebration of marriage and their residence. The only exception is when both spouses are aliens. C. When a Filipino father with American children who became such under the rule of jus soli dies, his succession shall be governed by Philippine law, also provided for under Article 16 of the new Civil Code. And D. If a will executed by an alien abroad is revoked in our country, the revocation must comply with the formalities of Philippine law, as provided for under Article 829 of the new Civil Code.
Now, what if the parties want the court to recognize a foreign law in their specific case? Before the court recognizes a foreign law in a specific case, there is a rule. Foreign law must be pleaded and proved. When foreign law has not been properly pleaded and proved, the internal or domestic law of the forum should be applied. Why? Because the reason of such particular rule is that our courts cannot take judicial notice of foreign laws. So how foreign law pleaded? Foreign law should be alleged in either of the following. Number 1, complaint or petition. 2, answer. 3, or any responsive pleadings. How foreign law prove under our rules of court? There are 2 scenarios here. If the law is written, it may be proved by 1, an official publication thereof, or 2, a copy of law attested by the officer having legal custody of the record or his deputy, accompanied by a certificate of any Philippine embassy, consular, or foreign service officer in a foreign service office in the foreign country where the record is kept, and authenticated by the seal of his office. It was provided by our rules of court under Rule 132, Section 25. The second scenario is, what if the law is unwritten? If the law is unwritten, it may be proved by 1, the oral testimony of expert witnesses, or by printed and published book of reports of decisions of the country involved if proved to commonly admitted in its courts, under Rule 130, Section 45 of our Rules of Court. Here, the law pertaining here are decisions of Supreme Court or customs of foreign country which recognizes as part of the law of the land in their country. Now, what is the essence of proving and alleging foreign law? Because there is a doctrine of processual presumption. When the foreign law has not been properly pleaded and proved, the court of the forum has the right to presume that the applicable foreign law is the same as the internal or domestic law of the forum. Therefore, the latter law should apply. Now, after proving and alleging a foreign law, how foreign law should be interpreted? The general rule is foreign law should be interpreted by the courts, the same interpretation as that given by foreign tribunals of the country where the law comes from. Exception: when the foreign statute is worded identically as the domestic law, therefore, the interpretation of the law of the forum will apply. However, there are instances that even after proving or alleging a foreign law cannot be applied in our courts. So these are the exceptions to the application of foreign law. 1. When the application of the foreign law would run counter to a sound and established public policy of the forum. Examples: divorce law or foreign law cannot be enforced here in the Philippines if the parties are both Filipinos, because our country doesn't recognize divorce. 2. A joint will executed by the Filipinos locally in foreign country is not valid, because our law and our public policy recognizes that a will is a personal act, not joint. 3. Incestuous marriage cannot be allowed because it is contrary to our public policy and it was provided by the family code that it is considered null and void. Note, even if they are valid in other countries, by reason of public policy, they are considered null and void. 2. When the foreign law is contrary to the almost universally conceded principles of morality, or what we call contra bonus mores. Example: foreign laws recognizing prostitution such as Germany, Switzerland, Greece, Austria, and many other countries in Europe. 3. When the foreign law involves procedural matters. Why? Because there are no vested rights in rules of procedure. Hence, a party to an action must submit himself to the procedural formalities of the forum. Example: an American cannot insist on a jury trial in the Philippines. Exception to the exception: when the law is both procedural and substantive, such as prescription and statute of fraud. 4th, when the foreign law is penal in character. Why? Because our law follows principle of territoriality in criminal cases. However, a penal clause in a contract entered into abroad may be enforced because such clause is not criminal in nature but only provides for liquidated damages. 5th, when the law is purely fiscal and administrative in nature. The reason behind this is because we are not bound to enforce foreign revenue or administrative laws. 6. When the foreign law might work undeniable injustice to the citizens or residents of the forum. Example: a foreign law putting the age of majority at 21 and refusing to recognize contracts of Filipinos abroad who are above 18 but below 21, considering the age of majority in our country is 18. 7th, when the application of the foreign law would endanger the vital interests of the state. And lastly, when the case involves real or personal property in our country. Why? Because we recognize the lex situs or lex recite to all properties, whether real or personal, found or located in the Philippines. Thank you and God bless.